Welcome everyone to a special Animal Legal Defense Fund CLE event, Professional Responsibility for the Animal Lawyer. My name is Priscilla Rader Culp. I'm the Education Program Manager for the Animal Legal Defense Fund and am delighted to be moderating this event today. Thank you all so much for joining us. Before getting started, just a few housekeeping notes. This is an interactive CLE that will include 4 pre-recorded segments to a hypothetical situation. After each segment, we will join back to discuss as a group. So please use the chat feature to both ask questions and answer questions asked by us, and that can be located at the bottom of your screen. The model rules for professional responsibility will apply. Additional resources, including the CLE packet, can be found on our website at aldf.org/webinars. Click on today's event and it will take you right to it. We'll also drop a direct link into the chat. This event does offer closed captioning. Closed captions are automatically turned off for attendees. To enable, click the caret icon near the CC button at the bottom of your screen and select Show Subtitles. To change the font size, click on Subtitle Settings, and we recommend keeping your mouse cursor off the Zoom monitor to prevent the captioning from moving up on the screen. This event is being recorded. A recording will be made available next week and can be found at aldf.org/webinars. This session has been approved for 1 hour of Ethics CLE credit by the Oregon State Bar Association. If you are seeking CLE credit, please select yes to the poll question that popped up. You will be asked to verify your attendance again later on in this presentation, and I'll go ahead and give a few seconds for everyone to make their selections. All right, thanks for that. And joining us today is Russ Mead, Shared Earth Foundation Visiting Professor at Lewis and Clark Law School. We will also have the opportunity to hear from Taylor Waters, Animal Legal Defense Fund Pro Bono Manager, to discuss the Pro Bono Network and ways that you can get involved. So with all that, I am very, very excited to introduce Russ. Russ Mead is a very popular lecturer nationwide who uses examples from his career as general counsel for animal rights organizations to illustrate animal welfare and other animal-related laws. Russ has worked for Best Friends Animal Society and Farm Sanctuary and is a beloved professor. As a former student, definitely can attest to that. In addition, Russ is active with legislative advocacy, grassroots advocacy, lobbying, and media promotion. Russ has authored several textbooks, including Nonprofit Animal Law, Farm Animal Law, Grassroots Animal Legislation, Trial Advocacy in Animal Law, and step-by-step legislative drafting for advocates. It's my absolute pleasure to welcome Russ. Thank you so much for being here, sharing your time and wisdom with us. And with that, we'll get started with the first segment, and afterwards, we'll see everyone back here to discuss. Thanks all.
Billy Miller is an attorney who loves the forest. In fact, Billy lives in an abandoned fire lookout on the edge of the coastal town of Fir Ridge. Billy was raised in Fir Ridge and continues to live and work in Fir Ridge as a mergers and acquisition lawyer. There's not much mergers and acquisition work in Fir Ridge, and Billy takes most meetings via Zoom from the top of the fire lookout. The main draw of Fir Ridge is the hiking trails in the forest. These trails have sweeping views of the ocean. Not surprisingly, the forest is inhabited by owls. Billy has loved owls ever since Billy was a kid. There's one famous owl in the region named Coconut the Owl. Coconut has their own webcam, a Facebook page, and as of today, 12,298 followers. People from all around the globe watch Coconut the Owl come and go. They were excited when Coconut's owlets learned how to fly. It was also big news when Coconut kicked their mate out of the nest after some kind of domestic owl spat. There is a new animal welfare group named Friends of Coconut that is based on all things Coconut the Owl. Billy attended the first meeting of the Friends of Coconut. Carl Simon, the founder and executive director of the group, started a discussion about a proposed timber sale by the state that would cut down Coconut's tree. The Friends of Coconut were in a rage about the proposed sale. A lot of people wondered if the sale could be blocked because Coconut lives in the forest where the timber sale would take place. Carl, the executive director, saw Billy, the lawyer, in the audience and asked, "Hey, Billy, you're a lawyer. Can we stop the timber sale based on Coconut?" Billy stood up and answered, "Sure. The state needs to balance the interest of wildlife with the need for pulp wood. Certainly, Coconut is more important than paper towels." Actually, Billy had no clue about what the law would be in this case. It's not an issue that Billy ever dealt with as a mergers and acquisitions lawyer. Billy did not even know if Coconut was in any way threatened or endangered. Billy had never read the Endangered Species Act. Billy just wanted to look smart in front of the group, which included several of the cool kids that called Billy a nerd in high school.
All right, Billy is up to it again. So I'll ask all of you, what's some professional responsibility rules that came into play that you noticed that Billy might have not exactly followed? I noticed one to get this started, and it's the not ever reading the Endangered Species Act and still talking on it. So
sure. So of course, there's two things to come into play. I mean, one is competence, and so that's rule 1.1 that says, you have to be competent to be able to represent a client and give advice. So the first question that people start asking me is, can I give advice as an animal rights lawyer? Can this be a practice area? What do I need to do to be that animal rights or animal welfare lawyer? Well, just kind of tongue in cheek, one of the things that I do if we were in person would have everybody raise their right hand, and I would swear you in officially as an animal rights lawyer. You'd be a member of the club, meaning it doesn't take anything from a legal standpoint to represent anybody in anything. Of course, we all know to be a patent lawyer, you have to do some other things, but almost any other kind of law, I mean, you can practice it as long as you take the time to get competent at it. And of course, in this case, Billy was not confident. It didn't matter that she was a mergers and acquisition lawyer. That was fine. What mattered is that she didn't do anything to raise her knowledge level to the point where she could be giving advice at all. That also brings up diligence 1.3 that says, if you're representing somebody, I mean, you got to work on their case. I mean, one of the things that'll get you, not you, of course, not any of the kind folks on this CLE, but get other lawyers in trouble, let me put it that way, is not taking the time to work on a matter that for some reason is difficult or not of interest, or they're not paying me on time or whatever it is, and that case just gets put to the side. That's one of the biggest reasons why people have complaints, bar complaints in particular, which could also lead to malpractice complaints. So if you're working with a client, you've got to work on the client's matters. In this case, Billy didn't do it. She just answered off the cuff. So yeah, you got to get ready to answer questions if you're going to answer questions at all, but you can pretty much take on anything you want to take on. What else is coming through on the questions here?
Yeah, get your questions and comments in there. So in looking at how Billy could have handled that situation, should she have, would it just been like, that's a really interesting point, let me look into that more, and then go and take the time to do that and come back? What would be the appropriate response?
Well, I think for the guiding light for the folks that are watching this is, how would you do this? How would you handle this if this was an important client to you, maybe a corporate client or a client that was maybe a little bit more formal? How would you handle it with them? I mean, and Priscilla, what you just said is something I used to do in practice all the time. Not give the answer off the cuff, because I mean, most of the time I knew the answer. I was close to having it nailed down. but there's always nuances, and there's always things that you remember or things that you've forgotten. And so it's quite common to say, well, let me look into that just a little bit, and I'll, call you back in half an hour, or let me just check our file, or, let me do whatever, and I'll get back with a really tight answer, and then come back with an answer that you could, defend 20 years from now. So yes, don't answer off the cuff unless it's something dead cold. But most of the time, you should really look at things. It's a good lawyer researches things. Yeah.
Yeah, nuance is so important. One little fact can change an entire, conclusion. So Lisa's bringing up confidentiality, which also kind of came up into play. If you can touch on that.
Yeah, so confidentiality, this is a weird one in terms of confidentiality, because the person asking the question was a member of a nonprofit, but they're the executive director, they were the manager. So are they waiving confidentiality because they're doing it in a public space? I think they might be. So the confidentiality piece, I think Billy is okay on, because they're responding in the same manner that the question was asked. So if it was asked in private and then you read out in public, I mean, you'd have a problem there. But it sounds to me like the executive director, was fully expecting, there to be a public answer. But there's other aspects about this. Let's see if other people came up with it.
So was there something about like scope? So we talked a little bit about diligence of knowing the ESA and the, protecting coconuts and everything, but the scope of their question, teasing that out a little bit more.
Yeah, so we've got the scope issue, but all of these things only come into play if we have a client. Here's the big thing. Do we have a client, my friends watching this? Are we, is this a representation at all? Or is this Billy just talking, like she would be talking to friends about, politics on television? So we got to answer that question first. None of this flows unless there's an attorney-client relationship, whether it's confidentiality, competence, any of this. Now, here's the scary part, and it's scary whenever anybody hears this. It doesn't take much to establish an attorney-client relationship. If you look at the preamble to the model rules, it basically says, and I've got it written down in front of me, it's so important, but I won't read it. If somebody asks you a question, a legal question, not what did you have for lunch, but a legal question, and you give them a legal answer, congratulations, you now have a new client. And that shocks most people. But it's the requesting for somebody to do legal services and somebody giving the legal services that starts that whole analysis. And you have to look at this from the perspective of the client. Did that person asking the question of a lawyer who likes animals and works on animal issues? What's their expectation? Do they believe that they're getting legal advice that they can rely on? Or do they think that this person is just, could be totally wrong? The client, people have a tendency to think, oh, I asked a lawyer and I got an answer, and they have a tendency to rely on that information. In this case, I think we're in the same boat. In my opinion, there's an attorney-client relationship going. Now, the way this should scare most of the people on this call, well, in fact, I want to use that chat function. Do we have the chat function signed on where people can make little comments?
We do. It's through the Q&A function.
Got it. So everybody, go ahead, and I'm not asking if you have ever done this. I'm asking, the question is, do you know of a time when somebody has asked a lawyer a question at a cocktail party and they responded? Go over into the chat and say, and again, not you, but do you know any lawyer that's ever done that? Go ahead and do that. That'll be kind of fun.
I'm getting overwhelming hand raises, yeses. Yeah, yes. I've definitely seen this at networking events. I've seen it at speaking events and at parties. Yep.
So we have to be careful. We have to know how little that it takes to establish that attorney-client relationship. So when you're at that holiday party, and let's face it, maybe some cocktails have been flowing. I mean, it's not the time to be establishing new client relationships. So the way out is to say, I would love to help you. this, if you would like, let's set an appointment. You can come into the office if you're still a lawyer that has an office and taking people there. I mean, almost everybody I know is working in virtual settings these days, not just from COVID, but from the shifting of the way we practice law. But make them look and feel like a client. The other thing is then you're going to ask the right questions to be able to give the advice. So, I mean, I don't know of any legal problem that I could answer the question from a single statement of a client. There's always the nuances you got to go figure out because the answers change. I mean, we all know that. And you can't really give advice unless you've sat there and you've asked, a half a dozen questions about the setting that the question is in. So yeah, be careful about creating these relationships. And yes, Billy has created one here. And yes, Billy has violated at least a couple of the rules of professional responsibility before he barely even gets started with this scenario.
I guess I do, going back to the scope question, if there is a attorney-client relationship formed there, was there anything then that came up within that conversation about scope to limit her involvement, such as on that particular issue?
Yes, very good for bringing me back to reality. Yeah. So in real relationships, and this unfortunately was a real one, lawyers, limit their scope. I even think back on reading about the way Abraham Lincoln would represent clients. He would write down the legal question that he was being asked, and then he would write the answer out so that he would limit the scope. Even, pre the age of anything electronic, he would define the scope of the representation, even when he's doing it with just a fountain pen. So it's very important, going all the way back to the beginning of practicing law, define what the scope is, because we all know that then as legal problems grow and take on a life of their own, the client will have thought that they have covered something that you didn't even look into or respond to. I mean, you weren't responding to rabbit hole B, and you only talked about, one thing that was laid out in front of you. So defining the scope, the question is, the answer is, and then of course recording somewhere, that's the advice you've given, so that if things go awry, you can, show what you've done. And also then you can figure out what work you've already done, and then also see what work you haven't done, so that you might be able to go back and backfill and say, hey, we didn't talk about me doing this, but there's this other angle. Would you like me to look into it? And would you like to be advised on it? And she didn't do any of that. Billy didn't do any of that. Billy just wanted to look smart in front of those high school kids that, pulled their hair when she was in 7th grade,
Yep. And always, get scope in writing, I would assume.
Well, I mean, that's the whole, whenever you establish an attorney-client relationship, I mean, there should be a writing. I mean, we learned that from every professional responsibility seminar we've ever been at, lay out the terms of the agreement, lay out the payment terms, lay out all of that. But also it's important to remember that you don't need a written contract to establish an attorney-client relationship. One has been established as soon as somebody asks you to do legal work and you do it. Good lawyers make sure that there's a representation letter in every single file they have. And I won't ask you to say if you know a lawyer who has ever taken a client without getting that, but I suspect I know the answer. Of course, people get busy and they don't do it. It's a good practice, because if nothing else, it runs the client through what your expectations are. And so just as a best practice from practice management, attorney-client letters are great, even though maybe not, they're not required to formally represent somebody. They're clearly not, but it's just a good management tool to know what you're being expected to do, and the client knows what they're being expected to do. It just cuts down on, bar complaints, malpractice complaints, everything else. So get it in writing, but for sure don't do what Billy did, which is take on new clients and not even really know or care that they were taking on a new client.
Thank you for that. And with that, we'll see what Billy is up to in segment 2.
Carl said, sure. And then added, we are not against logging. We just don't like clear cutting and certainly want to save enough trees for Coconut to have a home. Maybe you could push the Attorney General for a select cutting sale. Billy was picking up some blackberries at the local farmer's market and ran into Kim Solo. Kim is the chapter president of the Forest Preservation Society. This society opposes all timber sales for dozens of reasons. Kim asked Billy about the health of the trees next to the fire tower. Then the timber sale came up. Billy mentioned that Billy knew the state attorney general and asked if there was anything Billy should pass on to the attorney general. Kim said, "Tell the AG to just block that timber sale. The planet and the state needs every living tree to help reduce global warming. Nothing you can make out of that pulp is more important than cooling the planet down." Billy called and set a meeting with the attorney general. Billy called the AG just general, since the AG told Billy in law school that someday that they would be the state's attorney general. "Come on in, Billy, and let me know what you're doing." That was the response when Billy walked into the door of the AG. Billy handed the AG a baseball cap with the word general embroidered across the bill, which caused both of them to laugh out loud. Billy started straight in. "You know, General, the people in Fir Ridge are up in arms against this timber sale. The Friends of Coconut the Owl want the state to have a select cut to save Coconut the Owl's home. Then we have the Forest Preservation Society, who is pushing to block the timber sale to help global warming." The Attorney General said, "Well, there's just no way to stop some form of timber sale, Billy. The loggers and logging truck drivers want the jobs. With COVID, the paper goods supply chain is just all messed up. We might be able to slow down and have a selective timber sale, but the state would never go for a ban on all logging. Besides that, the state needs the money." Billy thanked the general and left after a bit of reminiscing about good old law school days. On the way out of the Capitol building, Billy saw a group of people marching in support of clear-cutting the forest. Billy saw the leader of the group, Benny Benedict, and stopped. Billy and Benny have disliked each other ever since high school. Billy accused Benny of stuffing the ballot box to beat out Billy of the winning of the slot as senior class president. Truth be known, Benny did stuff the ballot box, but would have won anyway. Billy yelled out to Benny, "Hey, you need to back down, Benny. If you don't, I'm going to tell everybody your sister helped you stuff that ballot box in high school." Benny's sister is running for county treasurer, and an accusation like this would be embarrassing to Benny's sister. Billy went back to the fire tower to post on Billy's blog what the Attorney General said about the timber sales. One advantage to living in a fire tower is a built-in cell reception in the internet. They're right there at the top of the tower. Billy wrote, "I just returned from the state capitol where I met with the Attorney General. It sounds like we may be able to convince the state to save Coconut the Owl's tree with a selective timber sale. But the Forest Preservation Society, listen up. There's just no way the state would ever block a timber sale of some kind." The internet postings just exploded. The Friends of Coconut were angry that Billy did not come to them privately to discuss the meeting. The Forest Preservation Society was even more furious that Billy had pitched the idea of a selective timber sale. The loggers and logging truck drivers were angry with Billy as Billy was messing with their livelihoods. The paper mill was screaming that Billy was trying to kill local jobs at the mill. Well, Billy poured some wine, got drunk, and responded to everyone. And this is what Billy wrote. "I've had it with the entire town. I'm not going to work on this issue any longer. I quit." Billy turned off her computer. For setup, picture Billy out there walking around and then starts getting asked another set of questions about going and stopping the timber sale. And then of course, it rolled into the meeting with the Attorney General. So with that clarification, what do you think we should be talking about?
Thank you for that clarification. I'm getting a lot of woes, a lot of wows, Billy,
Yeah.
comments, and people are wanting to start with the conflict of interest between all these groups that she's talking about.
Right. So the conflict, I mean, so the first thing we have to come down to is that that universal question, does Billy have a new client? And if we're using the definition of if somebody's asking you to perform legal services and you provide them, or put even simpler, more simply, if somebody asks you a legal question and you give them a legal answer, then now you have a client. I think we're clearly there. And do we have a conflict? Well, it's not the conflict that we think about, like when you represent, one party and then you're representing, the same party against them. It's not that bad of a conflict. But let me ask a question, and I can in the chat room get you to respond about things you know. Here's the question. Have you ever seen one animal nonprofit working on the same issue as another animal nonprofit, and the two nonprofits disagree about the correct way to handle the situation? So go ahead and put, have you ever seen that? Yes or no? Priscilla, let me know when some answers come in.
We have all the time. Yes. Yep. Yes.
Yep. And
constantly.
So we don't, when I say we, it's because I represented a lot of these organizations and fondly and have done great work with them. But you can have two cat organizations that both not only want to help cats, but they both want to help feral cats. And they absolutely hate each other's positions in the way that they want to do it. So two feral cat organizations can totally disagree on the right way to do it and spend as much time fighting each other as fighting the people that, don't like feral cats at all. And so, yes, I think anytime you're looking at representing two organizations on the same issue, there's not only is there a potential conflict, there's probably a conflict going in, because I have never seen the organizations 100% aligned. They might come together and work on the same issue because of some commonality, but boy, in terms of the way that they would want to be represented, no, it's not the same. And so there ends up being a conflict. And then that trips, all of those conflict rules. I mean, you need to go through and first of all, you got to identify the conflict. You've got to let both sides know about the conflict. If you're going to represent them both, they need to waive the conflict. I mean, there's a lot of steps to go through. And frankly, by the time you did it, the likelihood of everyone saying, yes, you can represent us both with these divergent interests is about zero. So yes, there very much is a conflict here. I think this is a real conflict. And with the way the facts are presented, there's a real conflict because there's a difference in what the outcome should be. They're not fighting for the same thing. One is looking for a selective cut that saves Coconut the Owl's tree, and the other ones are saying, no, don't cut any trees at all. I mean, that difference alone means that one person can't represent both of these organizations at the same time dealing with the same timber stand.
Yeah, completely different strategies, I'd reckon.
Yeah.
Lisa's also bringing up breach of confidentiality.
Yeah. So again, so confidentiality, this is one of those things that's misunderstood. And I usually don't have, I don't take the time in these to pull out the rules of professional responsibility and read them. But this is one area that you might want to just go and look at on your own. And here's the thing. Confidentiality in professional responsibility is not what you think. It's not preserving and protecting confidential information. That's not what it talks about at all. It talks about all information that you learn about when you're or from the client. So the client can tell you something that was posted in the newspaper. So it's not confidential in terms of trade secrets, but you can't divulge that if you got it from the client, even if it's something that's widely known to the public. And that's shocking to most people. No, it can't mean that. It can only be talking about, when they secretly confess their crimes, or they're talking about strategies. It's like, no, you learned about it when representing them. That's the whole sphere and bucket of information that we're talking about when you're talking about the model rules of professional responsibility, which is, of course, what it turns into the rules that you have to work under, because whatever state you live in has adopted those rules as law. So you can't really talk about this stuff. I mean, there's the exceptions are you can use whatever you need to use for the representation. You can certainly tell other people about your client's position in terms of the representation, but you just can't generally talk about your clients and your representation of them. Shocking. Most people don't realize that's the way it is. We don't get called on it very often, but that's what the rule is. So yes, so confidentiality. You're not allowed to talk about this stuff unless you have to talk about it to carry out the investigation is the clearest answer. There's some other exception as well, but the clearest thing is just don't talk about things unless you have to talk about things. What else did they see?
Yeah, so Nancy wants to talk about the bribes and the threats that went on, which
Oh yeah,
I definitely would like to talk about too.
Yeah, and those are two separate things. So there's the well, there's actually three things going on here.
Yeah.
So one that most people don't realize is that you can't go out and boast and say that you've got special influence or special connection with any kind of public official. And that's not just judges, but it's public officials. So when you start saying, you know, I can handle this because I'm good friends with the attorney general, or we used to date, or they're, you know, that we're in the same whatever club, boy, right there, that's a straight up violation. You cannot imply any kind of special relationship between you and any kind of official. So we've got that thing going. We got the baseball cap thing going. Now, yeah, is that a bribe? Of course, bribe is a strong word, and it depends on state law, figuring out if something is improper or a bribe. As a general rule, and of course, every state law is a little different, but you know, little small value gifts, you know, you can give away. So if you go, let's say, to a state representative's office, if you're lobbying, you'll see coffee mugs all over that the public has come and given to them, you know, highlighting their causes. Something like a ceramic coffee mug is good. The crystal one out of pewter, one custom made, maybe probably over the line. And again, it doesn't take much, you know, so you don't want to be doing, you know, that. So small symbolic things maybe. But the rule that people just don't realize at all is 4.4, it's harassing third parties. So there's actually a rule that says that you can't do anything that's going to embarrass a third party. So somebody who's not a party to the matter, if you start putting pressure on somebody to embarrass a family member or a friend of theirs, you know, like in this case saying, hey, you know, this happened way back in high school and now your sister is running for office and I'm going to embarrass your sister if you don't do something I want, that's a whole separate violation. So you cannot do anything that's going to embarrass or harass, you know, third parties. I don't want to call it an obscure rule. None of them are obscure, but it's one that we don't run across very often. So we've got all three of those at play. And it's interesting to me that they get pitched as a single idea, but when we tear them apart, no, we got three different things going on. So yeah, don't be implying you've got more power, or even if you have the power, you can't be using that to get the client. You know, you got to be really careful on the gifts. You know, if it's anything more than a coffee mug that you can buy at at the Walmart, you know, you got to be careful with that. And of course, then this embarrassing thing that, you know, most people don't know about.
Thank you. We are at time. I do want to flag that I'd like to talk a little bit about how she just quit in that blog post of hers next time, but we'll catch up.
How do you quit? How do you disengage
definitely
from
not that way.
Got it. Okay, right. Let's roll.
Let's roll the tape.
Every year, the Chamber of Commerce holds Forest Festival. It's a combination celebration of the trees, celebration of wildlife, has its own concert, art fair, and of course, a beer festival. When Billy arrived at the event, Billy stopped by the Friends of the Coconut booth. The executive director, who was no longer angry at Billy, told Billy the booth had run out of ice for the snow cone machine. Billy has a vintage Land Cruiser to get in and out of the forest, and the group asked Billy to run out and get 20 bags of ice. The group treasurer gave Billy $100 from the snow cone cash box to pay for the ice. Billy picked up the ice and threw in a bag of Santitas tortilla chips. They're vegan, you know. She pays the ice house with a debit card. While waiting for the concert to start, there was a lively and somewhat drunken discussion between Chamber of Commerce members as what is the best way to stop logging around Coconut's tree. Mike, a forest activist and board member of Friends of Coconut, suggests they could tell the loggers the tree had been spiked to stop them from cutting down the trees. Billy commented to no one in particular, "Hey, if you really do this, you better be wearing a mask so you're not caught. Remember, there are security cameras pointing at Coconut's tree." A John Denver tribute singer was brought in for the concert. Billy set up a lawn chair to listen to the concert and watch the sunset. Mike, the board member of the Friends of Coconut, pulled up a chair next to Billy. They were drinking Electric Owl. It is a beer that is popular in the area, and they were listening to Rocky Mountain High and Baby You Look Good to Me Tonight. Things went well between them. By the end of the night, Mike and Billy had walked into the forest and under an old-growth Douglas fir tree in a bed of ferns, well, how should we say it, saw the Aurora Borealis. Or as they say in the rules of professional responsibility, they had a sexual relationship.
All right. Do we
We're
want to
back.
go?
Sure.
We'll
We'll go back. So obviously there's a whole host of rules on how to withdraw. Look them up when you're really ready to withdraw. You know, you have to send notice. You have to send the files over. You have to make sure everybody knows of all of the deadlines coming. And of course, Billy didn't do any of that. And of course, did it publicly, quitting these clients out to the blogosphere. So wrong way to do it. All right. So what do we see in this segment?
All right. So Lisa's starting with the unsolicited illegal advice to spike the trees with a mask. So we can start there.
We'll start there. All right. So as you know, I try to make these things humorous, but I will also tell you that in my travels over the decades here, that I have seen people sit around and talking about doing illegal things. It's usually over some beer. It's usually just blowing off steam and anger over something that's happened, you know, to the animals. But let me talk about, you know, first of all, just go straight to the best practice. The best practice is for you not to be there and not be involved. And so, I mean, clearly Billy was improper by giving the advice of, you know, not getting caught. So you violate the rules of professional responsibility if you help somebody plan breaking the law. You also could have some responsibility for, you know, letting folks know that there is an intent to break the law. But if you find yourself in that situation, dig into it and, you know, learn the nuance because it's nuanced. But here's the best practice that I can really help all of you with. If you're in that situation, just announce, look, don't break the law. Don't tell them what breaking law is. Don't do an analysis because now you're starting to represent them. Just say, whatever you folks do, don't break the law. Get up and leave. What you don't want is for yourself to try to thread the needle and give good legal advice and have people, you know, to try to help them avoid breaking the law. Because if they do go off and they do something illegal, all anybody's going to remember is they planned it and the lawyer was there helping them plan it. You don't want to be that lawyer. So say don't break the law, stand up, leave, walk away. So that's the best practice on that. And that's not hypothetical. I have seen this.
Imagine, especially within advocacy, you know.
Oh, yeah. Advocacy and alcohol and animals that are being abused. Yeah, that's just ripe for comments for people to do illegal things to people who are causing animal harm. I will put it that way.
Yeah.
And you notice me not giving any details. Yeah.
So a lot of people are also picking up on the sexual relationship between her and either a potential client or an already established client.
Yeah.
So
the first analysis is this person a client or not? I mean, I set them up in these presentations. I have them be different things. They can be an assistant director. They can be a program director. It's always of some tied to a nonprofit that Billy represents. So in this case, it's a board member. So is a board member of a nonprofit the client? I think most analysis is going to say yes. Of course, that you'd have to look at the nuance of, but I would say generally yes. So I've set it up where she is having or they are having a sexual relationship with a client. But the rule doesn't say that you can't have a sexual relationship with a client. I mean, that's the piece that folks don't understand. What the rules of professional responsibility for the states that have it, and some states don't have it, they end up saying, well, you can't have a sexual relationship with a client unless you had a sexual relationship with that client before they became a client. Then it's okay. When you think about it, that makes some sense. Let's say you're representing your spouse in some kind of small criminal matter, some traffic infraction that happened to be on the criminal side, or even just the civil side, speeding ticket. If you had a sexual relationship with the spouse before the representation, you could do it after the representation. I mean, I gave one of these presentations at the Canadian Bar Association, and they don't have the rule, and they said it was, well, because we need to take care of those cases when it's okay to represent somebody you're having a sexual relationship with, and that actually does make some sense. And then there's Louisiana, and I have no idea why Louisiana says you can't. They don't want the rule at all. So yes, the rule is a little different than most people think, but you still need to be aware of it. No sexual relationships with a client unless you had the sexual relationship before. Do we have anything else?
Yes. So when she went to do a little shopping, and she both bought some stuff for the nonprofit and for herself, a little snack, how should she have handled that? So
the rule is simple. It says you have to safeguard your client's funds, and you have to segregate your client's funds. And so I set this one up to where it's kind of segregated. It's its own $100 bill. So I made that a little bit, debatable on what to have happen. And this time she did not pay for the food with the $100 bill. Had she done that, it would have been clearly commingling. All of this sets up with a best practice that I learned from a client decades ago, and I want to give it to you. We are asked to do this kind of thing as lawyers all the time. We're trusted. People trust us with their money. They trust us. We have driver's licenses with cars, and people know us as responsible, and we get asked to do things to help animals all the time. So here's the procedure that I learned that I like. Go buy whatever they want you to buy. Put it on your debit card, your credit card, whatever. Bring it back with the receipt. Hand them whatever you bought for them with the receipt, and have them reimburse you. That way, there has never been any commingling of money at all. When the money part was transpiring, you didn't have any client funds at all. And so you're absolutely clean. There is no way to get in trouble for that. And there's all kinds of ways to get in trouble if they hand you cash or, give you their debit card or whatever else. Just handle it, get reimbursed. You're in the clear, and it works every time. So best practice, never take the client's money to buy these small things and then go buy them. Instead, just get reimbursed. Wipes out all problems. Do we have anything else? Yeah.
It's kind of going back to the second, I believe, hypothetical, if that's okay, but wanting to talk a little bit about the professional decorum that took place and how that might be raised with the AG.
Oh, we have to remember that that we are lawyers. We're members of the court. They're permeated throughout the preamble of the rules of professional responsibility, as well as the rules themselves. We have to treat, in particular, judges, but also officials with proper respect and decorum. Unfortunately, in our society today, some of that is getting looser and looser, but it's still there for lawyers. So yes, you should treat official meetings with officials, as an official meeting. If you're good friends with the judge, with the AG, with whatever, fine. Whatever you're doing, when you're off on your own, trips together, or you're doing whatever is different and fine. But when you're in there representing a client, you have to treat it as if it's a business meeting, and do that, or else, you can start to get in trouble if somebody complains. And you got to remember that the complaints can come from anywhere. These rules of professional responsibility are designed as consumer protection laws. And so somebody that doesn't like you, somebody that is associated with one of your opponents, I mean, they can all raise, that you were violating rules of professional responsibility because of the way you conducted a meeting with the AG. It doesn't have to come from a complaint from your client. It doesn't have to come from the AG. It can come from the public. And so, yes, be careful about that. Be careful about that.
Very good to keep in mind.
So how are we doing on time, my friend?
We have a little bit before our conclusion, and I did just want to talk. So someone's asking, like, if you are at a party, was it okay for her to be at that party? And then also, what's your expectation for social situations like that? Could you give non-legal advice? Should she have been drinking? How do you kind of keep those lines clear if they're your friends, but also your client?
Yeah, I think, and this is a hard thing for folks to get their heads around, how do I act in social situations, and I'm a lawyer, and people know I'm a lawyer, and they start talking about legal stuff. Well, the hard answer is you shouldn't be talking about legal things in social settings unless you establish the attorney-client relationship and you treat them as clients. And so you shouldn't be having most of those conversations. They can absolutely get you into trouble. And the way they get you into trouble is you're thinking that you're just talking about child custody cases in general. And what's really going on is somebody is gleaning from you hints of information and then going off and acting on them in things that affect, children themselves, spouses, third parties. And you maybe unwittingly, have become part of their entire sphere. And so talking about public events is one thing, talking about, what you see on CNN is okay. But when you start talking about situations that are dealing with, private fact patterns, the alarm bell should go off and you just shouldn't go there. Again, it's, if you'd like to talk about this, make an appointment, you can come in and we can talk about it, whether you're going to charge them or not. But just don't talk about legal matters that are impacting the person that you're talking to. Again, current events kinds of things, you don't represent anybody. That's a whole different thing. You can certainly talk about that. But if you're talking about individual fact patterns, just don't go there. It's just as much as we want to help and as much as we want to tell somebody what the general state of child custody laws are, we just should not do that. And it's actually violates the rules of professional responsibility when we do. And again, I won't ask you if you've ever done it, but I could ask you if you've ever seen it done. And yeah, the whole thing's going to light up.
Yep.
Sorry, folks, we're lawyers.
Don't do
Those
it.
are clients out there when you start answering their questions.
Yeah, because even if you're just talking about something socially, you're looked at as an authority every time. And so the age-old question came up, and I think that this is a great one to leave on before we reach the conclusion. And it is, can you preface it by saying this is not legal advice? This is a question.
I've got a one-word answer.
Yep.
No.
No.
And
Yeah.
if you
Great
could,
question.
let me do an analogy. If you could, just think of all of the laws that you could avoid by saying, when I represent you, I don't have to follow rules of confidentiality. I don't have to follow embezzling money from you. I don't have to follow my responsibility to give you good advice. You waive your right to sue me for malpractice. If you put any of those things into a contract, it would absolutely be unenforceable. And even putting them in would probably be a violation of the rules of professional responsibility. So saying, hey, I'm not your lawyer, but let me just talk to you in general about this. No, it doesn't get you off the hook, because if it could, then you would be able, what you're really looking for is a waiver. And you're absolutely prohibited from waiving any of these consumer protections. So no, sorry, folks.
Yeah, it's a good question. It comes up every time. As a student, definitely try to find the loopholes and all that good stuff. But yeah, nope. And with that, we will move right into the conclusion. Thank you so much, Russ, and thank you all for such a great discussion. And we'll find out how it ends for Coconut the Owl and Billy.
Good. And out there, don't be Billy.
Don't be Billy.
Well, I'm sure you're wondering how everything ended up. So this is the conclusion. Well, there was a timber sale, but it was for a selective harvesting of trees only. Coconut and most of the trees in Coconut Owl's the forests were saved. 200 trees for every tree cut were planted in the area to help minimize the impact of the harvest on global warming. In between cases, Billy now travels to forest communities with Mike Osborne, where they catalog old-growth trees. And Coconut has made up with her mate and are back together. Thank you.
Perfect. And if there is any last questions, we can get to them, but otherwise, thank you so much to Russ Mead for sharing his time with us today. And thank you all to you for the discussion. We will now hear from Taylor Waters, Animal Legal Defense Fund Pro Bono Manager, to discuss the Animal Legal Defense Fund's Pro Bono Network, types of work that volunteer attorneys perform, and the benefits of membership. But before we do that, if you are seeking CLE credit, please respond yes to the poll question to verify that you're actively attending the session, and that will count as your attendance verification. And give a few seconds to complete that. Perfect. All right. We'll now hear that brief message from Taylor Waters. And if you are interested in getting involved with the Pro Bono Network as an attorney or a paralegal, you can reach out to Taylor after this event at probono@aldf.org, and she's happy to answer any questions. So we'll hear from Taylor now, and thank you so much.
Hi, we're here to talk about the Animal Legal Defense Fund's Pro Bono program. My name is Taylor Waters, and I am the Pro Bono Manager. So we're going to go through the various opportunities and engagement and who can join the network. So who can join the network? Anybody. Attorneys, paralegals, law students, general supporters, every law professional and interested person is welcome to join our network. All practice areas are welcome. All court admissions, legislative experience, skills, talents outside the law, and languages. Every facet of the individual legal professional that they can bring to the table is beneficial to the network, just because you never know when there's going to be a novel legal issue or a novel region that is going to need our assistance. So why pro bono? It's the right thing to do. It adds value to you as a person, legal professional, law student. It sharpens and broadens your skills, just because there are so many different things that attorneys and other legal professionals can help with. There's research and writing, there's drafting and filing amicus briefs, full-scale litigation, legislative opportunities. It's really the full gambit of what you can do as a law professional. We bring that to the table, and there's opportunities to help. It exposes you to new issues in the law. Oftentimes, what the Animal Legal Defense Fund is doing is finding novel ways to use existing laws, or in the legislative arena, kind of trying to advance new laws. So it's new issues, it's new ways to expand your existing practice areas with the overlap and the intersection with animal law, and we'll get into that in a little bit. It improves your networking opportunities, just because you're introducing yourself to a whole new group of attorneys, and there's other opportunities if you were to join the animal law section of your bar, other bar organizations, CLEs like this, where you have a chance to, see some new names and reach out to people that you weren't familiar with. It enhances your job fulfillment, just because you're doing something different. I know when I graduated law school, one of the first things that I was doing as an attorney was foreclosure defense, which was incredibly meaningful to me, but it wasn't why I went to law school. I went to law school for animal law. So through doing pro bono projects with the Animal Legal Defense Fund as a network attorney, it brought me back to what the whole point was in the beginning, and why I went out into this field. You gain meaningful experience, and the experience that you gain is unparalleled, depending on what the opportunity that comes your way. It builds office morale, just because you and the other legal professionals that you're with who are working on the projects with you will have other things to talk about. They'll have more fun things to talk about. Overall, it's such a positive thing to be working on that it is not the same old mundane that you might be used to. And it's a unique way to merge your profession with your passion and make a real difference. And those will be kind of immersed throughout the slides coming up. So I've already gone into this quite a bit. One thing we didn't mention very much was assisting with animal cruelty prosecution. So the Animal Legal Defense Fund has a variety of programs. I'm talking to you about the pro bono program directly, but there's also legislative affairs and criminal justice. And a lot of the pro bono network attorneys get to help on some of the prosecution with animal cruelty cases and being introduced to other attorneys who work on this. So if that was something that an attorney was interested in, we would also be able to connect other network attorneys to help expand that practice area for you and create those connections. What you gain when you get into the Animal Legal Defense Fund's pro bono network is not just, us doling out opportunities here and there. It is broader access to the entire network of other attorneys as well. So, for example, we occasionally get in requests from other attorneys who are taking on perhaps just a strange animal law case that they're not used to taking. They might want to talk with another local attorney who might have experience with that, or just two heads are better than one on certain projects. So it's everything from your normal legal professional responsibilities, research, writing, drafting, litigation, but into the more creative networking and projects, going to events, tabling, that kind of thing. So our requests come from two different streams. There's the public assistance requests that come directly from people in your communities, and then ones that come from the Animal Legal Defense Fund directly. The ones that come from the public, the normal people submit it's a form on our website. Those all come directly to me, and I send them directly to the network if it is the correct jurisdiction. So if you're admitted to practice wherever the case would have to be filed, if it's in your interest, I don't want to send things to you that you're not interested in. So we always try to match those pretty well with, so you're not getting things that just immediately hit that trash folder. And also, activities that you're interested in doing. So say you were like, I'm not a litigator, I don't want to litigate, I want nothing to do with litigation, we'll have them work. So you never get requests that hopefully are just off the table. My first real case that I would say I generated, but that the Animal Legal Defense Fund sent to me and I brought to a firm, was about a dog named Hank. He was a German Shepherd who was about a year old, and he had gone in for a surgery to remove an undescended testicle. His human was getting him neutered, and it was a complicated surgery just because of that undescended testicle. The veterinarian ended up taking out 4 organs from inside Hank, testicle 1, and in the process had sliced his bladder from his urethra and sewn it shut. So Hank was unable to empty his bladder. Hank spent several hours in extreme pain, and his last moments were truly horrible. His human brought him to MedVet, which is an emergency vet out here in Ohio, who ultimately had to make the decision to euthanize Hank. His human paid for a necropsy on him, which is very rare, and it really helped with his case because we were able to show that the veterinarian made these very affirmative choices that were not supported by veterinary medicine common sense. So we were able to get for Hank one of the largest settlements in Ohio for a veterinary medical malpractice claim, and that's true to this day. Ohio is a state where you get nominal value, so not too much, but because Hank was very highly trained, he wasn't neutered at the time before the surgery, and his humans had wanted to get another German Shepherd like Hank because they worked at a children's hospital, and Hank was going to go visit the children at the children's hospital. So you had kind of these compounding factors combined with the veterinarian's affirmative misconduct that really helped that case push through. That's one example. Veterinary med mal is probably one of the most common common types of public assistance requests that we get. But other things that come through fairly frequently for attorneys to get involved in is activist guidance. It's pretty common. Nonprofit organizations, rescues are always sending us requests for just an in-house attorney or an outside attorney to look through their contracts to assist them with legal issues as they arise. Provide general guidance, frankly, how they can better serve their communities through the law. So often nonprofit organizations will also want to get involved in whatever that state's legislature is doing to help make things more friendly for rescues and stray animals, for example, trap, neuter, release programs, that kind of thing. Oftentimes, though not as frequently, this would usually come through criminal justice, are the domestic violence cases and the link between domestic violence and animal abuse. It's pretty common that domestic violence abusers will also abuse animals in the home. So getting involved in not only specific cases, but the more broad issue of shelters across the country that allow animals to come in as well, because very often people will stay in a bad situation because they don't want to leave their pet behind. They're afraid that their cat, dog, ferret, hamster, bunny, you name it, will not make it if they leave, either due to direct abuse or negligence and neglect. Veterinary med mals, we talked about. Trusts for companion animals is more and more common all the time. People are realizing that they might outlive their furry companions and they don't want them to have nothing. So it's fairly common that occasionally we will get a request coming through saying, hey, you know, what can I do in my will and estate to make sure that somebody's there to care for my pet and that they are then cared for. Animal custody disputes, more common than you'd think. Often when people get married or enter into a relationship, they get animals, and when they divorce, it can be every bit as ugly as if they had had children. There's not the same kind of law behind what to do in those situations, but occasionally courts will agree to go with the best interests of the animal, and if they don't, attorneys are often needed to mediate between the couples or just create custody arrangements. I have had one where it was a couple that had broken up and they had been sharing custody of this dog, and eventually they decided they no longer wanted to share custody, that one of them wanted to keep it. So I got a spouse calling me, crying absolutely in tears because they were afraid that their former partner was going to just keep their dog. So those are fairly common. Dangerous dog designations, huge, both when they are initially found to be dangerous, appealing those decisions, but also dealing with people whose dog or cat has been attacked by another dog or cat. I haven't had 2 cats yet, but I'm sure it can happen. And dealing with the civil aspect of that as well. So they might want damages against whomever's dog hurt their dog or cat. Landlord-tenant issues, no pet policies, HOAs, condos. Often therapy dog issues are kind of lumped in with this as well, as distinct from service animal issues. The therapy animals are often not given the same credence by landlords, so helping tenants work through those issues and not lose their housing is very important, and those come through fairly frequently. Service animal issues, I had a great one that was against a grocery store, large grocery store chain out here in Ohio. And the service animal was a very large mastiff. When I say very large, I met this dog. He was like 250 pounds. He's a big boy. And somebody in the grocery store was afraid of him. So they let the store know that there was a dog in the store, and the store wrongfully kicked out a trained, vested service dog. So working with people who go through that as well. Our network and the Animal Legal Defense Fund on these projects is partnered with some of the largest and most well-respected law firms in the world. So it's a chance to get your name out there if you're a newer attorney or if you're a solo, to some of these other large firms and organizations that you might not otherwise get the chance to intersect with, either due to practice area differences or just not having those opportunities available. So it's a chance to partner not only with us, but with large firms as well. They use news clips from our pro bono cases for law firm recruitment videos just because it is such a happy, feel-good thing to get to be involved in. And it really increases the stature of both the attorneys and the firms just because they are able to work on these national public interest issues. Press releases come out on the larger cases. Right now, our network has had over 67,000 pro bono hours, more than $25 million in legal work to help animals, and that is going up all the time. It is an amazing way to broaden your impact. So you don't need to just take cases as they come down from us. There is never a requirement that any network member, legal professional, take a case that we offer. It's always, hey, if you're interested in this, let us know, we'll get you on it. There's no obligation at any time. And it's not the only way to help. You can also rock your connections with your elected officials, corporate leaders, celebrities, law firm leaders, influential community members. There are, in non-COVID times, conferences to attend and really broaden your network with these amazing other individuals who are interested in promotion of animal law. Let your employer know of your interest in animal law. So one thing that firms that I worked for were always really surprised about were the intersections between animal law and existing practice areas. Like I had mentioned before, I started out with foreclosure defense, landlord-tenant, that kind of thing. And there was always an animal law aspect to bring into any particular practice area. Landlord-tenant, you have pet restrictions. Foreclosure defense, sometimes you're dealing with a service animal that cannot be moved too easily. Consumer protection is absolutely massive for animal law. Family law, again, you have custodies, trust and estates, pet trusts. There is no aspect of the law that cannot directly intersect with animal law. So if it is something that you're interested in, I'd be happy to talk about how to incorporate that into your existing practice area and let your employer know of your interest so you can start bringing in these cases and really set yourself apart from other attorneys in your area. I have often heard from clients that they picked me as their attorney on a non-animal case because they were interested in that animal part of it. They thought that an attorney who is willing to devote so much of their practice and time to that is going to also be empathetic to their situation. So it says something on your resume and in your practice that says that you are an empathetic individual who genuinely cares. It helps set you apart from the attorneys who are only promoting their effective settlement rates and that kind of thing. It shows that you are not just an attorney, but a human. And I have never met a client that wouldn't rather work with a human than what they typically view attorneys to be like. Get your firm or business involved. Again, we offer a lot of resources. There's brochures, there's office trainings we're happy to do, there's pro bono week, summer associate programs. We can offer resources and trainings to help suit whatever your firm's goal is to both discuss animal law and work in pro bono opportunities to really broaden your firm and set you apart from our competitors. Animal law is an emerging field. The opportunity to support new legal precedent is amazing. Truly, my experiences as a network attorney, well, I'm working for the Animal Legal Defense Fund now, so it must have gone well, just in the sense that it supports growing so much as an attorney with exposure to new legal areas and just moving beyond the normal attorney practice. There's lots of volunteer opportunities in your community. I would say utilize Nextdoor app at your peril. You might find that your neighbors are crazier than you realize they were, particularly about animal issues. Get your offices, boards, local organizations to change their policies. Fight local efforts to expand wildlife hunting. And neighborhood cleanups are a big deal. Disaster response, fires, oil spills, etc. starting up trap, neuter, release programs. And, you know, when I was in law school, one of the things that I had made into a really big project that we ended up mailing out a model law for outlawing declawing and debarking of dogs. It didn't end up going anywhere just because I graduated and no one picked up the torch after me for this particular project. But getting those model laws and sharing them with your community to help there can be local ordinances against a lot of these things, and often changing the law through local ordinances is significantly easier than going statewide or waiting for a case to come up. Post outreach table leaflet. Again, there's all kinds of conferences and non-COVID times to get involved with. Petition drives, plant-based food giveaways, and feeding the hungry. Our shelters are always in need for additional animal or pet food. There might be pet food banks actually that you can get involved with and donate to. Host parties to benefit local nonprofits, serve on local boards, educate those in your church, civic groups, volunteer when traveling for work and vacation, and film screenings. A lot of these bullet points assume that you are actively involved with probably an organization or a group. But start one, start an organization, start a group. There's no end of need for that, and we'd be happy to help in any way. Lobby is one of my favorites. So get to know your local elected officials. Make that contact, and often they have open office hours to go in and discuss these issues. So say you're in a state or a locality where there's a new law coming down, or something where you think there's a big hole where there should be a law, go ahead and make an appointment. It doesn't hurt to gauge the temperature of a legislator. They are there to talk with you. If they can't be there to talk with you directly, they will have a staffer who is. And you might be able to find that you have an animal-friendly legislator in your area that can help introduce a bill and change the lives for thousands of animals. Follow your legislators and local elected officials on social media. That way you can know what they're up to, and share our rankings report with them. Our rankings report just came out again, and see where your state lies. Out here in Ohio, it's not so good, but knowing that and knowing what causes your state to be in that particular ranking and identifying those holes where there could be other laws is a big deal. And often legislators and elected officials don't know. They might think that their state is doing great as far as animal law, animal welfare, animal status in the legal system. And as soon as you're confronted with a rankings report that shows pretty clearly where you actually are, it can spur change. Letters to the editor. So connect with local newspapers. It's a powerful way to make your voice heard in the larger community. It's one of the most widely read sections. I know I always go there for the juicy gossip to see what people in my community are arguing about. And, it's a great way to be both heard by your community, but by elected officials as well, particularly if it makes a splash. There are a variety of animal law reviews and journals to submit scholarly work to. I would particularly promote the Journal of Animal and Natural Resource Law, just because I was its editor-in-chief back in law school, but all of these are truly phenomenal and a great way to get your work and your scholarship read by others. It's a great line item to add on your resume as well. And next time you're looking for a spot at a new firm or to discuss things with a client, it's as I mentioned before, it's an amazing humanizing factor that really sets you apart. If you have any questions on how to get involved further, on if I said something that, something that you're interested in on how to expand animal law into your practice area, if you're interested in our trainings, other resources, or just have a question about the network, go ahead and shoot me an email, probono@aldf.org. And that link below is how to join our network. All right. Thank you so much.
All right, thank you so much again. And if you are interested in becoming a volunteer attorney member or paralegal, please visit aldf.org/pro bono for more information and for the application form. If you have any questions, you can reach out to Taylor at probono@aldf.org. Big thanks again to Russ Mead for his time. If you are not a member of the Oregon State Bar Association, most states accept credits from other mandatory CLE states such as Oregon, but please check with your local bar association to confirm your state's reciprocity and reporting rules. Please also do take the survey that will pop up. It helps us in our future planning. You might need to click a blue continue button to access it. We hope everyone has a wonderful weekend. Thanks again for joining us, and we'll see you next time.